Students are joining. We will start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. And we are in the middle of a discussion on the schedules of the Constitution. On 26 January 1950, there were 8 schedules. Later on, 4 more schedules were added. First Constitutional Amendment Act 1951, 9th schedule. 52nd Constitutional Amendment Act 1985, 10th schedule, which deals with anti-defection law, which we will discuss today. 11th and 12th schedules. These were added in 1992-93 by way of 73rd and 74th Amendment. 73rd Amendment deals with Panchayati Raj institutions. 74th Amendment deals with municipalities or urban local bodies. Schedule 1 talks about details of the states and union territories that we have, the names and territorial extent of all the 28 states and 8 union territories specified in the first schedule. Schedule 2 talks about the salaries, emoluments of president, vice president, speaker, judges, CAG, so on and so forth. Schedule 3, it talks about oath and affirmation. When oath or affirmation is administered to a minister, to a judge, to a CAG, all these are mentioned in the Schedule 3 of the Constitution. Then Schedule 4 talks about representation of states in the Rajya Sabha. All the 28 states that we have and 2 union territories that we have, they will have representation in the Rajya Sabha. And what is that representation? That is provided under Schedule 4 of the Constitution. Now let's look at Schedule 5 of the Constitution. And this is where we will talk about tribals, who were previously considered as aboriginals, original inhabitant of this country. Now whether that theory is correct or incorrect, we don't have to get into that. One theory is known as the Aryan invasion theory. That means Aryans invaded India, which means Aryans came from outside. And when they came to India, there were the tribals already residing in India, aboriginals already residing in India. But because of the Aryan invasion, these individuals, original inhabitants of this country, they were pushed towards the forests. And then the Aryans invaded and captured the mainland India. There are a lot of sociologists, anthropologists who discredit this theory. But if we forget about the invasion part, just look at that, yes, these Aryans came from outside. Whether they invaded or not, that's a separate matter. Came from outside. But those who were originally residing this country, residing this land that becomes now India, they were pushed towards the forests. And these are different from the rest of the population. These are unique from the rest of the population. They maintain their own culture, distinctiveness, their language, their script. Now, when you look at the colonial period, these tribals, we saw a lot of uprisings. Many times in our history, these tribals, they rebelled against the colonial government, against the British government. And primary reason was money lending. These tribals, now the British would send its officers or non-tribals to these tribal areas, and they would give them money in the form of loan. But when this money they could not repay, their land was confiscated. And because of that, there was tribal uprisings. Not just that, these tribals would perform shifting agriculture. The entire land, and that is what we have discussed previously also, primitive communism. And that primitive communism where the entire land does not belong to individuals, but belongs to the community as a whole. This primitive communism was present in the tribal culture as well. The entire land belongs to the community as a whole. When this entire land belongs to the community as a whole, I am sowing some crops on a particular piece of land. After 2 years, 3 years, obviously the soil would reduce, would decrease, would shift this pattern to another portion of land. The entire land belongs to me, belongs to the tribals. British imposed restrictions on shifting agriculture. That was another reason of tribal uprisings. And you would read that in modern history, even before 1857 revolt, there have been 70 to 90 instances of tribal uprisings. When the Constitution was being written, the question arose, how do we deal with these tribals? Who are these tribals? Who are different from the people of the mainland India? J.S. Gure, one sociologist, he referred to tribals as backward Hindus. Basically called them backward. But they're not backward, they're unique, they're different. In fact, in some ways, their practices are more liberal than the practices of the mainland India. So don't call them backward, call them unique, different from the rest of the people who are residing and inhabiting the mainland India. Now the question was, how do we deal with them? Because they have their own culture, unique culture, different practices. And we have discussed some of the tribal practices when we discussed Uniform Civil Code. Pandit Nehru, and he had an advisor, Verrier Elvin. Together they decided that we should have some constitutional safeguards for these tribals. Pandit Nehru's position was, we should not make these tribals second-rate copy of ourselves. Let them decide how they want to develop. What is the pace of development that they wish to pursue? We should not impose our own idea of development on them. So some sort of isolation was practiced. One option was complete integration. Tribal culture disappears. Tribals and non-tribals, they are one, and we will have one common laws for the entire country. But that would not be respecting the diversity, because we are a country of diversity. That is why some policy of isolation was practiced vis-a-vis these tribals. So for these tribals, they should be able to maintain their own culture, own distinctiveness. And that is how constitutional safeguards were provided in the form of Schedule 5, in the form of Schedule 6 of the Constitution. Schedule 5 talks about and looks at that there is a significant tribal population. We will administer those as scheduled tribal areas. But these should be states other than Assam, Meghalaya, Mizoram, and Tripura. Why? Because these 4 states are exclusively dealt under Schedule 6 of the Constitution. So what are you saying? I'm talking about tribals, whom we refer to as aboriginals, the original inhabitants of this country. Because of whatever reason, they shifted from the mainland India and moved towards the forests. And in these forests, they maintain their own identity, distinctiveness, culture, language, script, all the practices. Now they have a history as well. During the colonial period, we have had a number of tribal uprisings as well. Sidhu, Kanu, so many tribal uprisings which we will discuss in modern history. Now the question was, how do we deal with these tribals under the constitution? Because now we are an independent country. Tribals are also part of an independent India. How do we deal with them? What is the policy that we will follow with respect to these tribals? One policy was integrate them completely with the rest of the country. And let's have common set of structures, common laws for the entire country. The other way would be respect the diversity of India, the tribal diversity that we have. And don't treat tribals as a single homogeneous group. You may call 10, 20, 15 as tribal groups, but all of them are different from each other, unique from each other, distinctively unique from each other. So tribals are not a homogeneous group. Just like the people inhabiting the mainland India, we are not homogeneous. So there may be Tamils, there may be Kannadigas, there may be Malayalis, there may be North Indians, there may be Gujaratis, there may be Marathis, and within Maharashtra also there is a different unique identity for different groups in Maharashtra. Similarly, calling all tribals as one would be foolish, because within the tribals there is a lot of diversity further. That is why we have to look at tribals who are from states Assam, Meghalaya, Mizoram and Tripura. We will give them protection under Schedule 6 of the Constitution. And in the rest of the country, wherever there are tribals, we will identify them and we will give them protection under Schedule 5 of the Constitution. But sir, why different treatment for tribals in these 4 areas, in these 4 states, and tribals in the rest of the country? When we look at tribals in the rest of the country, the argument given by constitutional experts is, if there are tribals in Jharkhand, if there are tribals in Chhattisgarh, all these tribals, more or less, they are similar to each other. That means we may, to a large extent, call these tribals of Chhattisgarh, Jharkhand, Rajasthan, Gujarat as some sort of a homogeneous group. But still we need to protect them. And what should we protect? We should protect their economic interests. But so far as tribals of Assam, Meghalaya, Mizoram and Tripura are concerned, for example, in Meghalaya, we have 3 different tribal groups: Garos, Khasis, Jintias. These are also 3 hills in Meghalaya, which is something that I'm sure you would discuss in geography. But Garos and Khasis are unique and different from each other. Jintias and Garos are different from each other. That means in these 4 states, tribals cannot be treated like a homogeneous group. One tribe is different from another tribe, unique. That is why we need to give them extra protection under Schedule 6 of the Constitution. But so far as tribals in the rest of the country is concerned, and we have 11 states in India where we have these tribals, Constitution says give them protection under Schedule 5 of the Constitution, but protect only their economic interests. How? President has the power. What is the power available with the president? President can establish, president can alter, president can abolish a scheduled tribal area. A tribal area where there is a significant tribal population in the entire country except Assam, Meghalaya, Mizoram and Tripura. What the president can do, identify a state, identify an area of a state where there is a significant tribal population, he will establish a scheduled tribal area. That means a tribal area which is under Schedule 5 of the Constitution, means it's a scheduled tribal area. President can abolish a tribal area, alter a tribal area, establish a tribal area. And then governor has the responsibility. Governor has the responsibility to ensure the administration of the scheduled tribal area, which means governor will administer a scheduled tribal area. And this time, in administering the scheduled tribal area, the governor may not even go by the advice of chief minister and his council of ministers. This is another reason why the office of governor should continue, because in absence of the office of governor, we cannot imagine any other institution performing this task, where the governor administers a scheduled tribal area, even without the aid and advice of the chief minister and the council of ministers. And how governor administers the scheduled tribal area? By establishing a council known as Tribes Advisory Council. In this Tribes Advisory Council, 3/4 members will be the tribal MLAs, rest nominated by the governor. Schedule 5 of the Constitution talks about the administration of a scheduled tribal area. President can establish a tribal area, can alter a tribal area, can abolish a tribal area. And now it is the responsibility of the governor to administer this tribal area. How will the governor administer this tribal area? By setting up a Tribes Advisory Council. What is this Tribes Advisory Council? For example, we have the state of Jharkhand. We know that in all the legislative assemblies in India, there are seats reserved for SCs, seats reserved for STs. Wherever there is an ST population, the seats are reserved for STs, the seats are reserved for SCs. Now in Jharkhand, for example, if a Tribes Advisory Council is established by the governor, 3/4 of the members of this Tribes Advisory Council will be the tribal MLAs. That means in this particular state, where seats are reserved for STs in the Legislative Assembly, those MLAs will become part of the Tribes Advisory Council. 3/4 of the members of the Tribes Advisory Council will be the tribal MLAs. The remaining would be nominated by the governor. What will be the role of the Tribes Advisory Council? As the name suggests, it will advise. Advise whom? Governor. On what grounds? How do you administer the scheduled tribal area? But sir, you told me that in Schedule 5, only economic interests should be protected. Because the only purpose of a Schedule 5 is to protect these tribals in their economic areas. That means the role of the Tribes Advisory Council is to advise the governor whether a law passed by parliament or a law passed by the state legislature, if this law talks about land transfer, if this law talks about transfer of land to non-tribals, if this law talks about money lending, whether this law will apply to the scheduled tribal area or not, or whether this law will apply with these modifications, that is something that will be advised to the governor by this Tribes Advisory Council. But this advice is not binding on the governor, because it is only an advice. But nevertheless, the governor, in administering this tribal area, would consult this Tribes Advisory Council. Long story short, Schedule 5 and Schedule 6 of the Constitution. It talks about the administration of the tribal areas. And what are these tribals? Different, unique individuals, unique groups. Schedule 5 talks about that we should protect only the economic interests of the tribals. How? The president will establish a tribal area. Once it is established, it is the job of the governor to administer this tribal area. How will governor administer this tribal area? By setting up a tribes advisory council. 3/4 of its members would be the tribal MLAs, remaining nominated by the governor. What will be their role? Their role would be to advise the governor. That, dear governor, there is a law passed by the state legislature. Dear governor, there is a law passed by the parliament with respect to land acquisition. Whether this tribal land can be transferred to non-tribals or not. Whether this tribal land can be given to Adani for the construction of a factory. Whether this tribal land can be given for industries. Whether money lending can be allowed in this tribal area or not. Whether this law passed by the state legislature or the parliament with respect to the economic interests of the tribals, whether these laws will apply to this tribal area or not, or will apply but with these modifications. Who will recommend, who will advise? This tribes advisory council. But this recommendation, this advice is not binding on the governor because it's only an advice. That means the title of this council is Tribes Advisory Council, to advise the governor. Governor has a special responsibility in administering these tribal areas. But so far as Schedule 6 is concerned, it talks about administrative provisions. How do we administer these tribal areas? But this time, the tribal areas in 4 states, Assam, Meghalaya, Mizoram, and Tripura. Why? Because when we look at the tribals of these 4 states, one tribe is different from another tribe. We can't treat them as homogeneous group. But when we look at the tribals of the rest of the country, there we see that there is a tribe and the another tribe and the another tribe, but they can be viewed as some sort of a homogeneous group where there is hardly any difference between one tribe and the other tribe. And it's not that the entire Assam, Meghalaya, Mizoram, and Tripura, these are the tribal states. There are 3 districts in Assam, 3 districts in Meghalaya, 3 in Mizoram, and 1 in Tripura. These are scheduled tribal areas in these 4 states. But since these tribes are different, unique from each other as well, Constitution says we have to protect not only their economic interests, but their culture. In Schedule 5, those areas which are under Schedule 5 of the Constitution, the provisions are we have to protect their economic interests. That means where it concerns money lending, where it concerns land, we have to protect those interests. But the areas under Schedule 6 of the Constitution, for these tribes, we have to protect not only their economic interests, but their customs, their language, their script, their family structure, everything we need to protect. And that is why Constitution says, for example, Meghalaya. In Meghalaya, if there is a district where there is one tribe dominating, a district where one tribe is residing, convert that district into an autonomous district. Listen to me carefully. Convert that district into an autonomous district. And this autonomous district will be provided with a district council. This district council is a democratic body. How? It's different from Tribes Advisory Council, where MLAs are nominated to this council, where other members are nominated to this council. But this district council is a democratic body, which means elections. That to direct elections. That means in Meghalaya, if there is one district, Khasi, where Khasis are residing, convert that district into an autonomous district. And this autonomous district will be provided with a district council. In this district council, people, that means Khasis, will directly elect their representatives. For example, if in this district council, it has 30 members, 26 will be elected. 4 will be nominated by the governor. But then what is the role of this district council? The role of the district council is that it will have a body which will have legislative powers. Another body will have executive powers. Another body will have judicial powers. Another body will have financial powers. Listen to me carefully. At the center, we have Lok Sabha. People of this country directly elect their MPs to Lok Sabha. At the state level, we have the state legislative assembly, where people of that state directly elect their MLAs. At the village level, we have Panchayati Raj institutions. At the city, urban area level, we have municipalities, urban local bodies. But so far as these tribal areas under Schedule 6 of the Constitution are concerned, we have given them some sort of autonomy. Autonomy in the sense that you will have a district council. In your particular district, it is as if you're running your entire country. You're running your own country. Because you will decide what are the taxes that you will impose on the people. You will decide what are going to be the laws related to education, laws related to marriage, laws related to inheritance, laws related to divorce. You will have the power to establish your own schools, govern your entire district without any interference from the state government, without any interference from the central government. That means now this district becomes some sort of an autonomous district where it is run by this district council on its own. And through this, we protect not only the economic interests of the tribals, but their social customs as well. Because whatever laws are related to marriage that they will decide, divorce, inheritance, how taxes can be imposed on the people, how taxes can be collected. And if there is a problem, if there is a dispute between 2 groups in this particular district, we will not go to a high court. We will go to this tribal court and it will administer justice based on its own tribal custom. Not based on Indian Penal Code, not based on Criminal Procedure Code, not based on any other code or any other law. Based on their own tribal judicial customs, they will decide who is guilty and who is not. So in the entire country, if we can call the entire country as an ocean, in this ocean there is an island, and this island is autonomous, that is a district council. But what if there is a district where one tribe is not dominating, where only one type of tribe is not residing? There are 2 tribes. Let's say tribe A, tribe B. Normally what happens, the state government declares that this area which is inhabited by tribe A is converted into a district. Area which is inhabited by B, tribe B, is converted into a district. But what if it is not? Then A and B areas are converted into autonomous regions. And these autonomous regions are given regional council. And this regional council, people of this A area, will directly elect their members. And they will decide then what sort of laws should be implemented here, what sort of justice should be given there. That is why if you look at when the law is passed by the parliament, these laws are not automatically applied to Schedule 6 areas. When a law is passed by the parliament, we say that this law is not automatically applicable to the Schedule 6 areas. In case of Assam, governor will decide whether this parliamentary law or this law passed by the state legislature, whether it will apply to the scheduled tribal areas of Assam or not. So far as Meghalaya, Mizoram and Tripura is concerned, governor and the president. Governor will decide whether a state law will be applicable to these areas or not. And president will decide whether a parliamentary law will be applicable to these states or not. And these Panchayati Raj institutions, they are present in Schedule 5 areas, but absent in Schedule 6 areas. So what does that mean? I will club the two schedules together. Schedule 5, Schedule 6 of the Constitution. What is the purpose of both these schedules? To protect the interest of the tribals. But tribals are not a homogeneous group. That is why tribals of Assam, Meghalaya, Mizoram and Tripura are dealt separately under Schedule 6, and the tribals of the rest of the country are dealt separately under Schedule 5 of the Constitution. And those who are under Schedule 5 of the Constitution, we need to protect only their economic interests. But so far as the tribals of Schedule 6 area is concerned, we have to protect not only their economic interests, but their social customs as well, their religion as well, their language as well, their faith as well, their judicial structure as well. That is why in Schedule 5 area, the president has the power to establish a tribal area. And then the governor of that state will have to administer that tribal area on the recommendations of Tribes Advisory Council. But the role of this council is limited. Limited in giving advice and limited in advising the governor with respect to economic matters of these tribals. Which means with respect to matters related to land, related to money lending of these tribals. But when we look at tribal areas under Schedule 6 of the Constitution in Assam, Meghalaya, Mizoram and Tripura, we want to give these tribals autonomy. That means run the way you want to run. We will not interfere. And for that, if there is a state, for example, Meghalaya, where there is one tribe group, Garos, who are inhabiting one district, that means Khasis, all the Khasis are residing in Khasi district, Garos in Garo, Jaintias in Jaintia. Now all these three districts are converted into autonomous districts. And these autonomous districts are provided with district council. That means people of Garos, they will elect their representatives in this district council. And then they will make their own laws. They will implement their own laws. They will impose their own taxes. They will punish people based on their own tribal culture whenever they have violated the tribal laws. Autonomy. But now there is a parliamentary law, let's say with respect to Uniform Civil Code. Let's say tomorrow a Uniform Civil Code is passed. Or let's say tomorrow land acquisition is passed. If I am the governor of Assam, I get to decide whether this parliamentary law will apply to Schedule 6 area or not. Whether the state law will apply to this tribal area or not. I am the governor of Assam. Governor of Assam is given special responsibility. So far as the governor and the president is concerned, in states such as Meghalaya, Mizoram and Tripura, the governor of the state will get to decide whether the state law will be applicable to this tribal area or not. And the president will get to decide whether parliamentary law will be applicable to these areas or not. Which means these district councils, these are basically democratic councils. When these are democratic councils, that is why we don't need Panchayati Raj institutions there. Why? Because if Panchayati Raj institutions are also established, it would be like duplication. Two democratic bodies performing the same duty. That is why Panchayati Raj institutions are absent in Schedule 6 areas, but they are present in Schedule 5 areas. So why are they present in Schedule 5 areas? Because Tribes Advisory Council is not a democratic body. Clear? If, for example, there is a state, Assam, Meghalaya, Mizoram and Tripura, where there is a district, but this district is not inhabited by one tribe. There are two tribes inhabiting this district. This entire district will be divided into two autonomous regions. These two autonomous regions will be given their own regional councils. These regional councils will have people directly elected by these tribals, and then they will pass laws for their own region. They will pass laws for their own region, implement laws in their own region, providing justice to their own people in this particular region. That is how we protect not only the economic interest, but also the social customs, religious customs, language, script, the family structure of these Schedule 6 areas. That is Schedule 5 and Schedule 6. So is it to say that whole Indian constitution does not apply to tribal area? No, the constitution applies. But when it comes to their cultural matters, related to their language, related to their script, related to their customs, we say they have autonomy. When we say Indian constitution is applicable, that means that the state is violating their fundamental rights, they can drag the state to the court. They have the reservation in government jobs and in educational institutions. They can also approach the President of India. Okay. Then there is Schedule 7 of the Constitution, which talks about distribution of legislative subjects. You have enrolled in BYJU'S and you want to prepare for the civil services examination. Clear? And you know BYJU'S will teach you all the subjects. But then internally we have to divide the subjects as well. I'll teach polity, Sham sir would teach economics, Chetan sir would teach IR, Mishra ji would teach history, Mukesh will teach geography. We've divided the subjects. In a similar fashion, if legislature of India has to pass laws on various items, we will have to divide these subjects as well. Some subjects will be given to parliament, you can make laws on this. Some subjects are given to states, you can make laws on this. And some subjects are common, where both parliament as well as state legislature will have the power to make laws. Those items where parliament has the sole power to make laws are in union list. For example, defense, atomic energy, foreign affairs, communication, banking, insurance. Those areas where the state has the power to make laws, they're under state list. For example, public order, prisons, local government, agriculture, fisheries, theatre, so on and so forth. And those where both center as well as state has the right to make law, power to make law, those are in concurrent list. For example, education, for example, electricity, for example, registration of births and deaths. And all this we will discuss in great detail in center-state relations. And hopefully we will initiate a discussion on the center-state relations today. Clear? Then we have Schedule 8 of the Constitution. And Schedule 8 talks about Indian languages. Originally, there were 14 languages mentioned under Schedule 8 of the Constitution. The current number is, how many languages do we have under Schedule 8 of the Constitution? 22 languages. And these are the 22 languages which are mentioned under Schedule 8 of the Constitution. But when we look at this chapter language, we can divide this chapter into 4 parts. 1, what is the official language of the Union? Second, what is the official language of a state? Regional languages. What is the languages of the judiciary and the text of laws that are passed by the parliament? And what are some special directives vis-a-vis language? Let's first look at what is the official language of the Union. But first you need to know what do we mean by official language. In which language am I discussing these matters today? English. That means we will use English as a mode of communication between the teacher and the students. We have a separate batch where only Hindi will be taught. No word of English would be spoken. That means there the medium of instruction is Hindi. Now I am center and you are states. In what language will we communicate with each other? That is known as the official language of the Union. There has to be a language which should be used to communicate with each other. Center has to issue directives to the states. In what language? For example, the current government will issue a directive to Tamil Nadu government in Hindi. They would never agree. And they would say it is not acceptable to us. Because I did not even understand what you mean by it. There will be chaos, confusion. And the Tamil Nadu government would reply in Tamil. Mr. Modi will not understand. So for the sake of clarity, we need an official language which we can use to communicate with each other. Which the union government will use to communicate with other states. Which the union government will use to communicate with each other's departments. And that language is Hindi in Devanagari script. So according to the Constitution, what is the official language of the union or the central government? That is Hindi in Devanagari script. But Constitution says that previously we were using English. And in 1950, we cannot suddenly shift to Hindi. We need to prepare ground for it. It can't be an overnight decision. That is why Constitution said that for 15 years, English will continue. Although official language of the union has to be Hindi, but we will implement this in 1965, 15 years later. For these 15 years, English will continue as the official language of the union. But then every 5 years, and then every 10 years, there should be a committee and the committee of the parliament on the official language. So what does that mean? What is the official language of the union? Hindi in Devanagari script. What is the national language of India? There is no national language of India. There is only one. There is only official language. There is no national language. So Hindi is not a national language. Hindi is the official language of the union. But the same Constitution says, if we were using English before, we will continue to use English after as well. But only for 15 years. Once 15 years are over, only Hindi will continue as the official language of the union. English will disappear. Because we can't make a shift immediately, instantly. We need to prepare ground for it. And for that, we will have a committee and we will also have a commission on the official language. That means one commission will be set up. What will be the job of this commission? It will advise the government that these are the areas where we should stop English. And these are the areas where we can only pursue Hindi. For example, this commission would say that Hindi should be used by the union when it is interacting, when it is communicating with the northern states. That means we can make this shift even now itself, 1955 itself. And while communicating with the southern states, we should continue to use English till 1965, maybe. And whatever report is given by this commission will be then examined by the committee of the parliament. And when would this commission and committee be set up? Constitution says first in every 5 years. That means in 1955. Then after 10 years. That means in 1960. A committee was set up in 1955. Official Language Commission, which was headed by B.G. Kher. And then the report of this commission was to be looked into by the committee of the parliament. That committee of the parliament was headed by Govind Ballabh Pant, GB Pant. What was the job of this commission? The job of this commission was to recommend in what areas can we stop the use of English, in what areas can we exclusively use Hindi, because come 1965, English will disappear as the official language of the union. Hindi alone will be the official language of the union. This commission was set up in 1955, but a committee which was envisaged in 1960, which had been set up in 1960 after 10 years of the commencement of the Constitution, was not set up. Why? Because we witnessed chaos, confusion, protests, emotional issues, where particularly in South India and more specifically in Madras, which is today's Tamil Nadu. People of southern states, particularly Madras, protested. Why should Hindi, which is a recent language, a new language, be imposed on the unwilling population of South India? Because in South India, we have our own beautiful classical languages. Tamil is a classical language, Kannada is a classical language, Odia is a classical language, Malayalam is a classical language, Telugu is a classical language. So why should our beautiful old classical languages be discriminated against and Hindi, which is a recent language, be imposed on the unwilling population of the South India? This is not acceptable to us. In fact, we can't speak Hindi, we can't understand Hindi, so why should Hindi be the official language of the union? We will not accept this. There were protests and there were few deaths as well. In fact, there was this anti-Hindi agitation in Madras And Tamil Nadu government, Madras government then, it went to another extreme. It said, whoever died in these anti-Hindi protests, anti-Hindi imposition protests, we will give them money as well. We will give them compensation as well. And we will give them pension as well. For their entire life, their families would get the pension. Those who died in this anti-Hindi agitation. Ultimately, a compromise was reached. What was the compromise? Official Languages Act was passed by the Indian Parliament in 1963. And this law says that both Hindi as well as English will continue to be the official language of the Union, notwithstanding anything. Notwithstanding the fact that Constitution says that English will not continue beyond 15 years of the commencement of the Constitution. Notwithstanding that, both Hindi and English will now be the official language of the Union. But sir, I have a question. Yes, what is the question? Sir, you said any law passed by the Parliament cannot violate the Constitution. If the Constitution says that the official language of the Union is Hindi in Devanagari script, and only for 15 years English will continue, after that Hindi will be the only sole official language of the Union, how can Parliament pass a law, that to an ordinary law, passed by simple majority, and say English and Hindi both will continue forever and ever and ever, there is no expiration term? How is that possible? That's possible because Constitution has allowed it. What Constitution has allowed? Constitution says, maybe the Constituent Assembly could anticipate something on this matter. Maybe they could anticipate that language is an emotional issue. Maybe they could anticipate that Hindi may not be acceptable to the people living south of India. That is why Constitution said, Hindi will be the official language of the Union, but for 15 years, English will continue. Can English continue beyond 15 years as well? Yes. For that, Parliament can make a law. And this law shall not be deemed as amendment to the Constitution. That means Parliament can enact a law. And through this law says, forget about expiry of 15 years. Even beyond 15 years, we can have English as continuing as the official language of the Union. That means a law can be passed by the Parliament, which is not amendment to the Constitution. That means there are some features of the Constitution which you can change by simple majority. That means Parliament can enact a law. And through this law, the Parliament can say, even if we said that 15 years is the expiry term of English, English can continue beyond 15 years as well. For that, you don't need to use Article 368. And to resolve the crisis that we witnessed in India against the Hindi imposition, the law was passed by the Parliament called Official Languages Act, and it is this Official Languages Act which says Indian Union, the Union of India, will have two official languages, Hindi as well as English, without any expiry term. And in Parliament also, for all the transaction of business, both Hindi as well as English will be used. While communicating with the states, both English and Hindi will be used. When the central government communicates with the people, both English as well as Hindi will be used. That is the official language of the Union. So official language of the Union, according to the Constitution, is Hindi in Devanagari script. But according to the Official Languages Act, it is both Hindi as well as English. Which means it is this act which enables the use of English indefinitely without any time limit. So what is Schedule 8 of the Constitution? It talks about 22 Indian languages. This chapter languages can be broken into 4 areas. First, what is the official language of the Union? And now we have understood that although according to the Constitution, the official language of the Union shall be Hindi in Devanagari script, but Constitution allows that English could be used for 15 years. Constitution allows that even beyond 15 years, if Parliament wants, it can enact a law and continue and extend English for indefinite period. And Parliament enacted a law known as Official Languages Act. Now, whether there are the proceedings of Parliament, whether there is communication between the central government and the state government, all this can be done in both the languages, Hindi as well as English, because both are the official languages of the Union. But so far as a national language is concerned, it does not exist. But what about regional languages? The states are free to choose their language. This is what we call linguistic federalism. If the Constitution would have empowered the center, that center you decide what should be the official language of a state. Official language of the state? In what language Tamil Nadu Legislative Assembly will function? How Tamil Nadu government would communicate with its own citizens, with its own residents? Then are we a federal polity? We are a unitary setup, where the center gets to decide what should be the official language of a state. But center does not get to decide. States get to decide themselves. That is linguistic federalism in us. West Bengal, you can decide your own official language. Tamil Nadu, you can decide your own official language. And not just one language. Any number of languages. And Constitution does not even say that their state, you have to choose the official language of the state only from this list. No. You can even go beyond Schedule 8 of the Constitution and choose a language as the official language of your state, even if it is not mentioned in the 8th schedule of the Constitution. Which means what is going to be the regional language? Constitution does not specify the official language of different states. That means giving states their own power. You decide your official language. Linguistic federalism. The legislature of a state may adopt one or more languages as the official language of the state. That means it's not necessary to have only one language. For example, in Telangana, it can be Telugu, it can be Urdu as well. Both these are the official languages of Telangana. It can be English as well. You can choose one or more languages as the official languages of the state. You can choose a language even if it is not mentioned in the Schedule 8 of the Constitution. For example, West Bengal. Bengali is our official language. Kurk, which is considered to be a language belonging to the Dravidian family. It is also the official language of West Bengal because the West Bengal legislature gets to decide 1, 2, how many official languages do we have. And even if a language is not mentioned in the Schedule 8 of the Constitution, that language also you can choose as the official language of your state. That is the regional language. But how will the union and the states communicate with each other? Both in Hindi as well as English? Because that's the official language of the union. But in what language will the states communicate with each other? Hindi as well as English, because that is the official language of the union. But states are free. If the states agree, they are free. Free to do what? To use only Hindi instead of English. And that is how some states such as Uttar Pradesh, Madhya Pradesh, Rajasthan, Chhattisgarh, they have decided that whenever we interact with each other, whenever we communicate with each other, we will not communicate in English, we will communicate only in Hindi. That is okay, that is provided. Which means how states are going to interact with each other. They can use Hindi as English, but we have empowered the states. If you want, you can only use Hindi in your communication. And that is how some of the northern states, they have an understanding with each other, that whenever we will communicate with each other, we will communicate only in Hindi and not in English. But what about the language of the judiciary and the text of the laws? English will be used in all the proceedings of the Supreme Court and in every High Court. Some of you may have witnessed the live proceedings of the Supreme Court. Because thanks to Supreme Court, now Constitution bench cases, a case involving 5 judges or more, they are live streamed on the YouTube channel of the Supreme Court official. And you would only hear English being spoken at the Supreme Court. Only English is spoken at the High Court. Because what is going to be the language of the superior judiciary? High Courts and Supreme Court, we call them superior judiciary. The language is only English. No Hindi, no any other language, only English. But what is going to be the language of the district courts? Subordinate courts. Regional language. Which means if we are in Karnataka, High Court will use English. Supreme Court will use English, only English. But the local courts in Karnataka, the district courts in Karnataka will use their regional language, their own official language, which is Kannada. Not just that, the authoritative text of all bills, acts, ordinances, orders, and bylaws at the central and the state level, English will be used. In fact, our constitution is in English. Although the translation of this English constitution was also done, but in 1950. That means we had 2 copies, Hindi constitution, English constitution. But listen to me carefully. When we had 2 copies of the constitution, Hindi as well as English, but later the constitution was amended. First constitutional amendment, second, third, fourth, fifth, so on and so forth. Only the English constitution was updated. Hindi constitution was not. When Mr. Vajpayee became the Prime Minister in 2003, he decided to amend the constitution and said, now all these amendments to Indian constitution which have taken place, all those translations will also be done. And this authoritative text in Hindi language of Indian constitution would have the same sanctity as the constitution itself. So what does that mean? That means in 1949, when constitution was adopted, we had 2 constitutions in different languages, Hindi and English. Both are the constitution, both have the same sanctity as the constitution. But later on, when the constitution was amended, only the English constitution would be updated, not the Hindi one. Mr. Vajpayee became the Prime Minister and said from now onwards, even an amendment to the Indian constitution would have to be translated in Hindi as well, so that this Hindi constitution is also updated with the amendments. And now this amendment to the Hindi constitution is also the authoritative text of constitution. That means it has the same status as that of the English constitution. Similarly, there has been an instance where an individual filed a habeas corpus petition in Hindi. This matter reached the Supreme Court. Supreme Court rejected this petition, saying we use English only and not Hindi in the communication. So in the superior judiciary, which is the High Courts and the Supreme Court, only English is used. But now, thanks to Chief Justice of India, Justice Chandrachud, what Justice Chandrachud has said, all the judgments that we have been giving, all the judgments that we will be given, we will use artificial intelligence tools to translate these judgments in the local languages as well, in the regional languages as well, so that these judgments are understood by the lawyers who are working and operating at the district level, where regional languages are used, so that these judgments are understood by the common people as well in their own language. But what is the language to be used at the High Court and Supreme Court? English only, although the judgments can be translated as well. And what is the language to be used at the district level, subordinate level in a state? Their own regional language. Clear? Then what are some special directives? Article 350 of the Constitution. I have a complaint. The complaint is, I am not given the ration card, I am in Tamil Nadu. I am not given Aadhaar card, I am in Tamil Nadu. Clear? I will have to approach the authorities in Tamil Nadu. Why are you not giving me the ration card? Why are you not giving me the Aadhaar card? In which language should I communicate? I have a grievance. I have a complaint. In what language should I communicate with the official in Tamil Nadu? In any language which is spoken in Tamil Nadu and any language which is spoken at the Union. What is the language spoken at the Union? English as well as Hindi. What is the language spoken in Tamil Nadu? English as well as Tamil. But I can file this complaint in Hindi language as well. Because every aggrieved individual, every individual who has an issue, who has a problem, who has a concern, has the right to submit representation to address this grievance in any language which is used in the Union or in the states. For example, in Uttar Pradesh, I can submit my complaint in English only. Because in Uttar Pradesh, Hindi is the official language. But since English is the language used at the center as well, I can submit this complaint in English language as well. That's Article 350 of the Constitution. Article 350 capital A is something that we have discussed multiple times. We are in Tamil Nadu, but there are migrants from Maharashtra. That means these are linguistic minorities. It shall be the duty of the state of Tamil Nadu to provide education to the children of these linguistic minorities in their own mother tongue, which is Marathi, till at least primary stage of their education, till 5th standard. That's a special directive vis-a-vis language. And a constitutional body is created, known as a special officer for linguistic minorities. All these linguistic minorities, whether Marathis in Tamil Nadu, whether Tamils in Delhi, whether Bengalis in Delhi, whatever problems you are facing because of your language, whatever concerns that you have, whatever discrimination you are facing because of your language, you just have to approach the officer appointed by the president, a constitutional officer known as the Special Officer for Linguistic Minorities. And it will be the job of this individual to investigate all matters relating to the constitutional safeguards for linguistic minorities. Any problems that you have, get in touch with the special officer. He will investigate, submit report to the president, and president will take the action. In fact, this is a state. Listen to me carefully. This is a state where there is one linguistic minority. In the rest of the state, X language is spoken. In the remaining part of the state, Y language is spoken. But here is this small language, Z. Those who speak this language, they also want protection. They also want dignity. What they can do, they can approach the president. Madam President said, what? We are linguistic minorities in our own state. We want our language to be protected, preserved. Said, yes, you can do that. Article 29 is your fundamental right. Every section of citizens residing anywhere within the territory of India, if you have a distinct language, script, and culture of your own, you have the fundamental right to preserve that culture. So that's your fundamental right. Yes, ma'am, but we want our language also to be recognized as the state official language. President has to listen to this and refer this matter to the state. There are people in your state who need protection, whose language needs to be protected. Their claim is that our language should also be made as the official language. Please consider. That is also the job of the President of India. Because language is an emotional issue in India. Every now and then you will hear Hindi being dominated, Hindi being imposed. Is this right or wrong? This at least is constitutional. So you may accuse the central government of using Hindi at the expense of other languages, but they are not doing anything unconstitutional. Because Article 351 of the Constitution imposes a duty on the union, on the central government, that what you have to do, you have to promote Hindi. So that Hindi serves as the medium of expression for all the elements of the culture, of the composite culture of India. Say, look at Germany. Germany is developing because the entire country speaks one language. China is developing because the entire country speaks one language. Japan is developing because the entire country speaks one language. Why can't we also speak one language? And that one language can be Hindi. Right or wrong? But Germany is speaking one language because there is no diversity in Germany. There was no diversity in Japan. There is no diversity in China. But there is linguistic diversity in India, where people speak multiple languages, different languages. You can't impose one language on the entire country, at least not through force. If people voluntarily adopt Hindi, learn Hindi, understand Hindi, speak Hindi, then over a period of time, Hindi can emerge as one common language which can bind the entire country together. Because let's also accept, Hindi is a language which is at least understood, if not spoken well, by majority of the people in India. English is the language of elites, or the educated class at least. Beyond Tamil Nadu, Tamil would not be understood. Beyond Andhra and Telangana, Telugu would not be understood. Beyond Gujarat, Gujarati may not be understood. But beyond the borders, if there is one language which can be understood, at least understood by the majority, if not spoken by the majority, that is Hindi. So over a period of time, we can take steps without imposing Hindi, but we can take steps so that Hindi is also popularized in South India. And over a period of time, Hindi becomes a link language which can link different people together. Because when I travel to Tamil Nadu, I don't know the language Tamil, the beautiful language, but I don't know it. So in what language should I link with the people of Tamil Nadu? What should be that link language? That can be English, that can be Hindi. But English spoken by the educated class. Illiterate class, they may speak Hindi. So can Hindi become a link language at least, which can bind the people of the entire country together? Yes, it can. And for that, there is a duty on the union that you have to promote Hindi, so that Hindi becomes or serves as the medium of expression for all the elements of the composite culture of India. But sir, why Tamil Nadu people are so reluctant to Hindi? Sakshan, you tell me, why are you so reluctant to understand Tamil? You learn Tamil. Okay. Now, what are the classical languages? There are 6 classical languages: Sanskrit, Tamil, Telugu, Kannada, Malayalam, and the last one to be given the status of a classical language was Odia. To everyone's surprise, Hindi is not a classical language either. But what is a classical language? And how do we define language as classical? You say, this is a classical movie, right? Casablanca is a classical movie. Shawshank Redemption is a classical movie. Mughal Azam is a classical movie. Sholay is a classical movie. I'm sorry, I don't know much of the cinema in the southern India or the local regional cinema. Otherwise, I would have cited their examples as well. But that doesn't mean I don't respect diversity, just that I don't watch. Classical movie or a classical song is something which stands the test of time. Casablanca, very old movie. Even today, people watch it. Why? Because it has stood the test of time. It's considered to be the most romantic movie of all time. Similarly, if there's a language which has a long history and is still being used today, it has not disappeared, it has not gone extinct, it is still being used today and flourishing, that language is a classical language. High antiquity, that means it's a language where the text of this language date back to 1500 to 12,000 years. And it should be original, not derived from other languages. It should be an original language. Such languages are what we call classical languages, recognized by the center. But then what is the benefit of a classical language? The benefit is, once a language is declared classical, it gets financial assistance for setting up a center of excellence for the study of that language. The only way we can protect a language, preserve a language, promote a language, is if more and more people opt to study this language. If we can set up centers in different parts of the country where this language would be taught, we will see more and more people opt for this language, study this language, and hence this language would be preserved. For that, we need money. And financial assistance is given as soon as your language is declared as a classical language, so that on this particular language, we can set up a center of excellence. Once a language is declared classical, University Grants Commission can be requested to create, at least to start with central universities, number of professional chairs for classical languages for scholars of eminence in the language. What does that mean? You want to enroll in a graduate or a postgraduate program in a university. What is the thought process in your mind? You will opt for that course provided it gives you later employment opportunities as well. If a classical language has a course in central universities, I may opt for it. Why? I will see there will be less takers for Sanskrit language, which means there will be less number of students, which means there is less competition as well. Because for Sanskrit, we will have departments in all the universities in India. Less number of takers, that means the supply is less, but demand is good. Ultimately, I will get a better job. So if for these classical languages, in all the central universities, if they're the scholars of this language, they will get to teach, which means more and more people will opt for this program. Language will be documented, language will be preserved, language will not go extinct. That is what happens when a language is given a classical language status. But in 1963, when there was a compromise we reached, that okay, let's not push Hindi as the only official language of the union, we will have Hindi as well as English as the official language of the union. At the same time, 3-language formula was also prescribed. What is the 3-language formula? That means the kids, the students till the 10th standard should be taught 3 languages. If it is Southern India, your own regional language, which may be Tamil, Kannada, Telugu, Malayalam. Second language would be English. Third language would be Hindi. That means in Southern India, 3 languages should be taught to the students. Their own language so that they don't protest our languages being discriminated against. English, because English is no longer only a language, English is a skill. And this skill gives you good access to quality jobs. And third, Hindi, so that Hindi is also popularized in South India. Because Article 351, it shall be the duty of the Union to promote the spread of Hindi language so that Hindi emerges as a medium of expression for all the elements of the composite culture. Same compromise in North India as well. So people in North India, students in North India, kids in North India will also be taught 3 languages. One, Hindi, which is their language, local language. Second, English, which is now a skill. And third, they should preferably select a very strong, beautiful South Indian language. So that South Indian languages are promoted in Northern India. Hindi is promoted in the Southern India. Beautiful. This was the 3-language formula. But over a period of time, we have seen something else. Tamil Nadu says we don't agree with 3-language formula. We will agree with 2-language formula. We will only teach Tamil and English. Meghalaya does the same thing. We will teach only 2 languages. Tripura says the same thing. We will teach only 2 languages. North Indian states say if we have to teach Hindi, English, and third language, this third language should be Sanskrit. We will not teach the South Indian languages. So we can say that this 3-language formula, which meant that the state government should adopt and vigorously implement the 3-language formula, which includes the study of the modern Indian language, preferably one of the southern languages, apart from Hindi and English, in Hindi-speaking states, and of Hindi along with regional language and English in non-Hindi states. But what has happened is Hindi is not taught in the states of Tamil Nadu, Tripura, and Puducherry, says the Ministry of Home Affairs. If you notice closely, Leonardo DiCaprio was mind-blowing in Shawshank Redemption. You might have watched a different Shawshank, because in my Shawshank there is no Leonardo. But separately, if you look at Ministry of Home Affairs, there are various departments. Department of Home, States. One is the Department of Official Language. Why this department was kept in Home Ministry? Because on official language there would be protests. There was a danger, a threat to internal security because of this official language. That is why this department is in the Home Ministry, Department of Official Language. And Home Ministry has said that when it's Hindi, Hindi is not taught in the states of Tamil Nadu, Tripura, and Puducherry. In many Hindi-speaking states, Sanskrit became the third language instead of any modern regional language, preferably South Indian language. Whereas the non-Hindi-speaking state like Tamil Nadu operates through a 2-language formula, Tamil and English, says the Ministry of Home Affairs. Now we have a new national education policy, which we will discuss in social issues, where there is another controversy on this 3-language formula, whether it is optional or whether it is mandatory. Because there have been states which are demanding that we should not overburden kids by forcing them to study 3 languages. 2-language formula is more than enough. But the states have the option to decide whether they want to implement a 3-language formula or a 2-language formula. Although the new national education policy encourages the states to vigorously implement 3-language formula. That completes our discussion on languages, Schedule 8 of the Constitution. We'll discuss Schedule 9, then we will take up questions, then we will take a break, and after the break we will discuss 10th schedule. But what is the Schedule 9 of the Constitution? We have discussed this multiple times, but we will just recap it now. First, Constitutional Amendment Act, 1951. 9th schedule was added to the Constitution. Any law which is placed in 9th schedule, Constitution said no judicial review. Judiciary cannot review the constitutionality of a law which is placed in 9th schedule, which basically means any law which is placed in 9th schedule has immunity. It cannot be reviewed by the judiciary. But then came Keshavananda Bharti case, which was decided by the court on the 24th April 1973, where the Supreme Court propounded a doctrine known as the doctrine of basic structure. There are some things which you cannot violate, even by amending the Constitution. And in 1980, Supreme Court said judicial review is also part of the basic structure. The case was Minerva Mills. Now the question before the court was, in Vaman Rao, in I.R. Kolo, in 1981, in 2007, the question before the court was, what will happen to this law which is placed in 9th schedule? Can we review now these laws placed in 9th schedule? Because although the Constitution said no judicial review, but in 1980 the court said judicial review is part of the basic structure of the Constitution. In Vaman Rao versus Union of India in 1981, the Supreme Court said all laws placed in 9th schedule before this date, there will be no judicial review. But all laws placed in 9th schedule after 24th April 1973, there will be judicial review. Why? Because if on 24th April, Supreme Court innovated a doctrine called basic structure, one such basic structure is judicial review. That means any law placed in 9th schedule cannot get immunity. It has to be reviewed. It will be reviewed. It can be reviewed. Even if Constitution says there is no judicial review. Because judicial review is part of the basic structure of the Constitution. But then in I.R. Kolo case, the Supreme Court said something else. For example, there is a law, listen to me carefully, which is placed in 9th schedule. But this law is placed after 24th April 1973. That means on this particular law, there can be judicial review. That means you can question the validity of this law placed in 9th schedule. Yes. But even then this law has some protection. This law can violate Constitution. But this law cannot violate basic structure. That means there is a law passed by the Parliament which says there can be no discrimination when it comes to public employment on the grounds of religion, race, caste, sex, place of birth, descent, so on and so forth. What if tomorrow state passes a law and says that in reserving posts in government jobs, we will discriminate on the grounds of residence? To prevent a challenge to this law, this is placed in 9th schedule after 24th April 1973. Will this law still get some sort of protection? Yes. Is this law violating the constitution? Yes. Because constitution says there can be no discrimination on the grounds of residence. But when this law is placed in 9th schedule, if discrimination on the grounds of residence is not a basic structure, then this law will continue, even if it is violating the constitution. But it is not violating the basic structure. Similarly, there are states, for example, Maharashtra, where if you read today's newspaper, there have been protests demanding Maratha reservation. Some MLAs, some MPs belonging to Shiv Sena Shinde camp, they've also resigned. This protest has turned violent as well in Pune and in other areas. Now, if there are states such as Maharashtra, Telangana, Tamil Nadu, they want to extend reservation beyond 50%. And they place this law which have extended reservation beyond 50% in 9th schedule. If the court would have said that 50% cap, 50% limit on reservation is a basic structure, then these laws would be unconstitutional. Because you are placing this law in 9th schedule, but we can review it and you have violated the basic structure, these laws are unconstitutional. So Tamil Nadu, Maharashtra, Telangana cannot reserve seats beyond 50%. But the court has said that 50%